Hi everyone! Today we're covering the Idaho versus Bryan Kohberger pretrial conference that took place on May 15th. We're gonna go over the most important new facts and details, but before we get into it, don't forget to subscribe so that you don't miss any updates on the Idaho 4 case. Welcome to my channel. My name is Lana and I have many interests. One of them is currently following this case. In my coverage, I try to be clear, concise, and to the point. We go over court documents and summarize hearings. We try to mainly stick to the facts, but when something doesn't fit, we talk about it. So if that sounds interesting to you, you're welcome to join us. As for the video today, let's dive right in. A big portion of this conference was Judge Hippler giving some very technical instructions to both the defense and prosecution. For example, he stressed that he wants them to be brief and to the point, that they don't waste the court's time. Both sides have to agree with which exhibits will be shown during the opening statements. For example, by 5 p.m. every day, each side is going to have to provide the other side with a list of witnesses that they intend to call the next day to testify, and with the evidence that they intend to present in connection with those witness testimonies. Make each other aware of what they're going to be talking about so that everything runs as smoothly as it can. The general stuff, pretty much. But by the way he explained things, you would think that this is the first trial for the members of the defense and the prosecution. And on the one hand, I kind of understand that perhaps each judge wants things done a certain way and that each state has perhaps slight variations in how they handle these cases, how they handle trials. But overall, yeah, it seemed very technical and basic information that did not need to be stressed. But as I said, for some of it, I get it. So the state and the defense already agreed on how they're going to present the IGG information, or the IGG tip, as it's now become. And that document is sealed. We don't have access to that. We're going to see it, or we're going to see how they handle this when the trial starts. But we went over the reason why they needed to find common ground on this topic. We went over this in my previous video. So basically, both the defense and the prosecution wanted the IGG investigative genetic genealogy information thrown out, and then they agreed that they're going to present it as a tip. And the judge told them, well, you're going to have to come to an agreement for how you're going to present the IGG tip. Judge Hippler also wanted the state and the defense to agree on how they're going to handle the touch DNA topic, because there was a problem with the expression here, what touch DNA may imply versus what it actually means. How this will be explained to the jury, so they're going to have to find some common ground on this as well, how they're going to go about handling this. Next, we have the famously not to scale 3D model of the King Road house. It's done. It is at the courthouse, actually, and the defense already had 2 experts to review it. At the moment, Ann Taylor didn't seem to have any specific objections to it, apart from the fact that the defense in general didn't want this not to scale 3D model because it was not to scale. But as we know, Judge Hippler decided, nope, it's fine, we can have the 3D model even if it's not up to scale. Why they wasted all that time and money on the Faro scanning, we will never know, but alas. Yeah, the dollhouse is finished, it's here, and I guess they're gonna be wheeling it into the courtroom when needed, and when it's not needed, it's going to be stored somewhere safe. They discussed how and where it's going to be kept, because I guess the defense just doesn't want anyone tampering with it. Now, for alternative perpetrators, the defense has yet to submit some more evidence, and then the state will have some time to respond. Then they will have a hearing. So far, they agreed on June 18th. The next topic they discussed were the jury questionnaires. These are going to be sealed, they're going to be confidential. There's a lot of concern, regarding the identity of the jurors once they're selected, but also the questionnaires themselves. They don't want anything leaked. And then in future closed hearings, they will be going through, the defense and the state, and the judge, of course, will be going through these jury questionnaires. What follows will be the jury selection. I really hope this goes smoothly, because honestly, finding an impartial jury for this case, it will be a big challenge, as the judge himself mentioned as well. Now, the jurors, once they're selected and when the trial begins, they will be addressed by the defense and the prosecution by their scramble numbers.
Potential jurors' faces and names obviously won't be broadcast.
Correct. The faces will not be broadcast, and you are to only use their scramble number as their identity throughout this. So they will never, you will never speak their name, nor will I or the court. It'll only be by that scramble number, and the camera view will not show their faces.
And the judge also stressed that the defense and the prosecution, or anyone affiliated with the case, anyone on either team, is not to interact with the members of the jury once those are selected. Pretty standard once again, right? Now, in regards to how the trial will be filmed, apparently there will be video, like a static camera, static video, and the judge said that there will be no zooming in, zooming out, no editing allowed, right? It will just be pretty much, I imagine, like these hearings, where it's just the camera showing different parts of the courtroom, different people. And yes, which people will be shown on camera and which ones will not be shown. We'll get to that in a second. As far as the plan for the trial itself goes, so it'll be a Monday through Friday schedule. They will start each morning at 8:45 with the jury sessions that will last until about 3:30. From 8:15 to 8:45, so in that half an hour before the trial, Judge Hippler will use this time to discuss with the state and the defense any questions or issues. He also mentioned a couple of dates where there will be no trial: September 1st, October 2nd, 3rd, and 13th, and November 11th, for example. And now we get to the topic of reserved seating. So Judge Hippler said he will be reserving 4 seats for members of Brian Kohberger's family. So I guess we're assuming his dad, mom, and his 2 sisters. And Taylor did say that on some days, maybe some other extended family members might like to attend. And the judge said, well, do let me know in advance who and when they will be attending, and we'll see what we can do about that. As for the victims' families, they already have reserved seating, obviously. And then there's an interesting one. Judge Hippler said he would like to reserve 2 extra seats for the other 2 victims, as he called them, so the 2 surviving roommates. But he also said that he doesn't know if they will actually want to be physically present in the courtroom because of how the media has been treating them. And yeah, that he would like to reserve the seats for them, but he suspects they will not want to be there. And it seems that some witnesses will be allowed to remote testify. Now, the fact that 2 surviving roommates who were in the house while these unalivings took place, while the crime took place, one of these 2 is an eyewitness, essentially. And the fact that they don't have to be physically there, that they can testify, via video, that is interesting to say the least. Thompson basically confirms that Bethany and Dylan will apparently be remote testifying, but as far as the live stream in the courtroom during trial goes, he doesn't want the he doesn't want the cameras on them.
Your Honor, may I also ask the court in regard to the live stream from the witness stand? I believe that we mentioned this, at least in passing, in our trial brief. State anticipates that we may have witnesses who, for reasons the court articulated about the other 2 victims, surviving victims, that a public live stream where their images could be captured and played games with in the media world. Is it possible for the video of that live stream when they testify to be shut off and just have the audio?
My intent would be with respect to victims, and I've already indicated I think the 2 roommates are victims. There is a compelling interest to protect them. If the victim requests it, their face will not be shown during the broadcast.
Most people who follow this case know who the roommates are, they know what they look like. And the thing with the roommates is, the fact is they are witnesses in this quadruple homicide case. And I understand trying to accommodate them to a certain degree, because what they went through certainly was no fun. But on the other hand, at a certain point, it becomes a little bit ridiculous. My 2 cents. Now we get to a little bit of a head scratcher. This is possibly the most interesting thing brought up during this pretrial conference. So, the display of a weapon. To date, they never confirmed or even mentioned that a or the murder weapon has been found. Only the knife sheath, as far as we know. But at the conference, the judge mentioned that there will be a display case for the display of a weapon.
Physical object exhibits work with the marshals on getting them in the courthouse. So, for example, if it's something that's going to raise alarms at the security line, such as, I don't know, a knife. I don't think there are any guns in this case, so I'm not as worried about that in terms of those being pointed at anyone by accident. But in terms of the knife, it'll probably be in a display case.
So now, of course, the question is, does that mean they have the actual weapon? Have they found it? Or is this going to be more like a demonstrative example where they bring out a similar or identical type of a knife that was used? We've heard that at least 2 types of weapons have been used on at least Kaylee. So perhaps they have a different one of those other weapons. Because after 2.5 years, I doubt that the weapon suddenly appeared, unless they've been hiding this from us this whole time. Which is also possible, so I guess we'll see. Then the judge had kind of an odd request, and again, good luck finding jurors who are like this. So he wants the jury to be aware, or he says they will be made aware, obviously, that this is a DP case. But when they're passing their judgment, when they're deciding if Kohberger is guilty or not, he doesn't want them to think that this is the punishment, that this is what they're subjecting him to. Can a human even function like this? Can you separate these thoughts? You can't not think about the consequences of your decision if you have been previously made aware of what the consequences are.
In a capital case, we are supposed to instruct them under 700B of the capital instructions in the pre-proof phase that it is a capital case, which obviously they're going to know through jury selection. So there's that instruction in there. And what I've done is we're also supposed to instruct them with 700C, which is this is a capital case and you'll have to decide if you find the defendant guilty, what penalty to impose. But then 700C says instruct them in a separate instruction. Don't concern yourself with the subject of penalty or punishment in the guilt phase. I've combined those 2 things together. So take a look at that. I think it reads better than trying to do 2 separate, potentially contradictory instructions.
I guess the point is he doesn't want them to be swayed by emotion. He doesn't want the jury to be too emotional when they're passing judgment. But at the end of the day, humans are subjective creatures. And don't think for a second that the defense and the prosecution aren't going to try to win the jury over. I mean, this is kind of the whole point. Who can make a better case? Who can make a better argument? Who can be more convincing? And the last big topic is that the judge sort of hinted at the media, social media issues. The more people that talk to the media and the more things that are in the media that are not admissible, whether they are true or not, the more difficult it makes things for the court. He also brought up the violations of the non-dissemination order, and alarm bells started ringing right away. NBC's Dateline episode on Bryan Kohberger. I checked it out, but I didn't want to talk about it specifically because we don't know how legit this information is. We don't know if it's true, we don't know if it's speculation, allegation, we don't know if things are edited, we don't even know where they got this information, and that's what the court is now trying to find out.
In the closed session this morning, I indicated to you I am going to be entering an order requiring retention of records by the state, and I'm going to write another one extending that to the defense as it relates to violations of the non-dissemination order. It does require some action on your part, counsel. And as I indicated, I would be open to a request for a appointment of a special prosecutor, and that special prosecutor to ask for a magistrate inquiry so they have the power of subpoena and the power to question witnesses under oath, as well as the power to grant immunity.
Now, to give you an example, in the Dateline episode, they showed a video of a car driving past, so it was the camera on 112 King Road. So they showed a video of the car driving in and out of the neighborhood. And there was a dog barking and some sort of distorted sounds, and that looked pretty legit. It looked exactly like in the court documents we got 2 screenshots of the suspect vehicle that looked like they're from this exact video. So that one looked pretty real. But what about the audio? Is the audio fake or real? Is it matched up correctly? We have no idea. And to be fair, in the age of AI, I'm pretty sure there's ways where you could fake that video. I'm not saying that's what they did, but you could. Then in the episode, they also bring up some blurry photos that are allegedly from Brian Kohberger's phone. How they got them, are they real, are they edited or not? Who knows? And then it gets even more ridiculous because in the Dateline episode, they talk about how Brian Kohberger allegedly Googled Ted Bundy. A criminology student, PhD criminology student, Googles one of the most notorious criminals. Shocking, really, truly. Next is Brian Kohberger taking selfies in a black hoodie. It's very clear that it was intended as a hit piece, in my opinion. Now, indeed, there are some potentially suspicious and creepy and gross things mentioned about him and grape corn, but again, we don't know if that's true. If it is, that might throw a different light on things, absolutely. But we don't know, because no official source has confirmed this. And clearly, the official source, aka the judge, is unhappy with what happened here. So yeah, Hippler wants to find the source of the leak. He wants to know, for all the people involved in the case, who they talked to, who they communicated with, in what sort of way, in what capacity, and also who had the information or access to the information that was in the Dateline episode. He also wants a written plan from the state for how they could prevent such leaks in the future, and he is suggesting that he would be in favor of a separate special prosecutor to investigate these leaks. Very serious business, as it should be, taken very seriously, and I say hip hip hooray for Hippler on this one. So that's about it for the Idaho 4 pretrial conference. Thank you very much for sticking around until the end. Next Sunday is my birthday, so if there are any updates on the case or new documents dropped around the weekend, I may be a bit late to covering them, just so that you know that there might not be a lot happening next weekend, but I'll get to them as soon as I can. Let me know all your thoughts on this case, take care, and I'll see you soon. Thanks for watching.